selectivity as well. So, any questions so far before we kick off? Is that all clear? Good. Excellent. So, without further ado, let us have a look at the two groups. We're looking at the justifications of the criminal prosecutions as a tool of transitional justice in Cambodia, specifically through the mechanism of the Khmer Rouge Tribunal, the ECCC. So, two groups. First group, a rather truncated group. There's been some issues with today's selections of the group of four, so they've been whittled down to two. I'm sure they'll do a great job. So, Vibha and Jessica.
Agreement on what should happen or what shouldn't happen. 35 years it doesn't seem enough, but the sort of most grave punishment that you could give out, a capital punishment, wouldn't be enough either.
Do we know why it was 35? Well, actually, the 35 years case, the Duik case that I was involved in, was 35 years after trial, and that was actually increased to life imprisonment after the Supreme Court chamber looked at the case again. But do we know why it was given 35 years, or why life sentences are given in this way? What's it based on?
Wasn't this for the former judge because he had already served time in custody?
Yeah. What I was getting at, well, that's the point that I'm very keen to raise with the group. What I was getting at was these sentences are not handed out completely indiscriminately. There is a body of jurisprudence of sentencing, so there will be aggravating and mitigating features, just as there would be in domestic courts, although they'll be applied slightly differently because of the nature of international crime, the systemic nature of the crimes, the fact that perhaps individual culpability is somewhat different. But let me come back to your point, Brian, about Duik and the sentence that was given to him initially by the trial chamber. So Duik was the commandant of the Khmer Rouge most serious torture and execution centre, S21. Under his watch, we, the prosecution, could prove 12,388 people were tortured and then killed in a period of about 2.5 years. The difficulty with the Duik case, from a sentencing point of view, is that he was picked up in 1999 by the Cambodian authorities and detained without trial up until the prosecution was able to get going in the Khmer Rouge Tribunal. So he was detained for in the region of 7 years without lawful authority. So the question arose that the defence quite properly raised: what recompense is there for Duik's human rights? That he was held without trial, he was held without charge for that length of time, which we all know is a violation of due process. Do we think that due process rights should not exist, or should be somehow compromised in international trials? Jessica?
I think that's completely wrong view. The fact is that this trial was these trials were trying to bring a sense of justice towards people, and the fact is that the people that died and the people that were under that regime, they didn't have their human rights listened to, they didn't have all that. But that doesn't mean that you should then say, well, just it's like an eye for an eye sort of argument. That doesn't mean you can do that. The fact is he didn't have his human rights were violated, and if you're going to set any kind of example, it should be made, it should be done regardless of who that person is. So he should, without a doubt, be in prison. I think that's why he was put in prison for 7 years prior to, without being held accountable. But that doesn't make it right. And the law is, in theory, meant to make things right. So I think you can't just say that due process or people's human rights in these sort of cases should be put to the side, because it just would make a mockery of everything else that's happened before.
Okay.
additional point to make to what she said. Two wrongs definitely doesn't make a right, and just because somebody did something wrong, holding them without the due process of law makes it a complete mockery of the law. But here I stand to question whether retributive justice is something that can be applicable when it comes to offences of such a grave and mass nature.
What do people think? Is retributive justice even possible for crimes in which, such as this, between 1.7 and 2.2, if you go by demographic statistics, people were killed or lost their lives through starvation or disease? Is it even possible? Do we look at what the society wants? I'm going to tell you a story, an anecdote. So there'll be a couple of these in my seminar, so forgive me, bear with me for these. So when I was at the Cambodia Tribunal, I was asked by my boss, the senior prosecutor, to go on a radio talk show. And it was to do with the Khmer Rouge Tribunal, and there was a phone-in show on questions about the tribunal. I was going to say this to a later slide, but as it's raised, I'll raise it now. One of the first callers, and there was a translator sitting next to me, these were Cambodian people, ordinary Cambodian people, phoning into the station, asked me, well, you know, Duik, the commandant of S21, he tortured people, or he gave orders to torture. Why shouldn't we torture him in prison, just as he tortured other people? The second caller that I dealt with came up with this. So these senior leaders are 68, 79, 82 years of age. They're going to be given 35, 40, maybe life imprisonment. They're going to die in prison, right? So can you, Mr. International Prosecutor, chain the bones of the deceased in prison? Chain them up. So he doesn't just die in prison, his bones are locked up in prison. And the reason for that, and it was explained to me later on by one of my Cambodian friends, the cultural significance of being able to bury the dead with an appropriate ceremony, like in many cultures, would be so violated by this idea that the bones could be chained up, that this would, only this would demonstrate, would be sufficient for the local culture and in terms of retributive justice. Those were two very difficult questions to answer. Well, the first one, not so difficult in the sense that I could say, well, Cambodia is a signatory to the Convention Against Torture. It is not permitted under international law to torture, even though the people that we're incarcerating and investigating tortured others, and that's not a moral norm that the international community recognises. But the second one, a little bit more complicated. So I hope that sort of demonstrates to you that actually what people want, the ordinary citizens want in the country, isn't always possible, and it's not always consistent morally or culturally with what the international community does in cooperation with the domestic authorities. Any other points on proportionality of sentence?
I think that, like you were saying, those things where that then the line starts to blur. I think when you say like, oh, 35 years isn't long enough. Obviously, like Aidan was saying, that you can't justify what's happened. You're never going to be able to say this is proportionate, but it's then what other positives the trial brings about, like the truths, and for people to just, like the ECCC was including victims in it and letting them give statements. And I think if you were to say, oh, 35 years isn't long enough, then, or they should be tortured as well, that's when it starts to be vengeance, that's when it starts to be revenge. And the point of trying to push this idea of retributive justice is ensuring that it is retributive and that vengeance and all these other factors don't kind of seep in and become part of the trial as well.
Good point, sorry, remind me next.
Ruth.
Thanks, Ruth. Brian.
I would like to think that when we said that the sentence of 35 years was not long enough, is that it wasn't sort of an explicit term for lengthening the sentence, because like it has been said, the guy was old anyway, so he was probably going to die within the 35 years. But I feel like the victim's access to justice goes beyond just retributive justice and trying to punish the offenders. Victim's access to justice looks at sort of going forward from that punishment. And that access to justice isn't just seeing that perpetrator face a life sentence, or in some cases death penalties. It sees sort of, because victims have often go through a lot of horrors in those crimes against humanity, it also encompasses reintegrating them into societies, providing sort of psychological support, compensation where possible. And I think perhaps the most important one is providing a sense of deterrence so that those radical evils do not happen again. And like has been said in the readings, retributive justice is impossible in the face of radical evils. So I guess the biggest access to justice for the victims is to ensure that those crimes against humanity don't happen through a deterrent feature.
Some good points you both raised, Brian and Ruth. Have you got to say?
Yeah. While talking about deterrence, is it really like giving someone a life imprisonment for an atrocity as huge as a genocide? Will really retribution or deterrence work in this context? Because like if you're going by the retributive theory, it's definitely not, it's nowhere close to being enough punishment for any of the crime and violations that have happened. There's no access to victims, there's no victims' access to justice, and there is nothing for the victims out of this except for like a conviction in, And that part, secondly, you're saying if you want to go by the second theory and saying that there's deterrence, it builds deterrence. Does it really though, saying that 3 or 4 of the top people have been held for killing so many millions of people, does that really, like the fact that we respect due process of law and all of that, and that's more important, does that really, it reinforces and, your belief in the democratic system and rule of law, but does it really act as a deterrent?
Well, we'll come on to deterrence. We'll have to after a short break after 2 o'clock. But you're all dealing with grappling with some of the big issues of international criminal justice as a function of transitional justice, and how it can operate on the same level of fairness, of punishment, in contrast to domestic criminal law. We'll see, especially specifically when we come to deterrence, as a theory it's been much challenged. But before we move on to sort of the general theories, I just want to come back to the ECCC. And really, I think Group 1 had the harder task, because Group 2 quite rightly pointed out some of the major criticisms of the ECCC. I mean, it is obviously easier to criticise than it is to justify international criminal justice, and transitional justice as well is perhaps no different. You can criticise, as the groups have said, the fact that there was political interference, that there was the Prime Minister of Cambodia, Hun Sen, uttering on a regular basis, "There shall be no more than 5. Well, thanks, Mr. Prime Minister, but it's not your job to tell us, as the operators of the tribunals, who we should and who we shouldn't investigate. Imagine if Theresa May started saying, "Okay, you can't have any more murder investigations this year because we've reached our quota." And the criticisms that there was this corruption. Cambodian society and Cambodian legal culture is meshed and mired in corruption. It's just the way the system works. There's no functioning rule of law, so the only way that you can win your case, if you're rich enough to do so, is to bribe the judge so that they follow your particular case. It's too slow. Yes, absolutely. You could certainly argue that the procedure has taken far too long to get to where it is. That's not necessarily the fault of the Khmer Rouge Tribunal. I'd argue that it isn't, because we have the small matter of the Cold War in the way. Without going into the detail of the history of why the Khmer Rouge came about, it was done very well by Group 1. It was really the Khmer Rouge driven out of power by the Vietnamese. The Vietnamese had just won the Vietnam War, or as they call it, the American War. And on the basis of the enemy of my enemy is my friend, the Khmer Rouge ended up being the seat of government in the United Nations, or the representatives of the United Nations, even after they'd been kicked out of the country by Vietnam. And the Khmer Rouge ended up holding on to the seat in New York with the UN for, I think, 15 years afterwards, notwithstanding the allegations that had been surfacing. So yeah, many criticisms, but let's perhaps look at some of the less obvious positives about the Khmer Rouge Tribunal. Ruth, you mentioned this as well, the question of truth. Well, we'll look at truth later on in the seminars, but truth is quite a malleable concept. You know, whose truth are you looking at? Are you looking at the truth of particular stakeholders in the justice process? Are you looking at the truth of the international community? The truth of victims? But when you look at it from a perspective of it being a record, a historical record whereby there have been challenges in a courtroom to the evidence, and the judges have found particular facts based on the give and take of the courtroom, you're entitled to at least suggest that there are facts that have been found in quite trying circumstances. So the question of, has that been ventilated in Cambodia? Yes, it has. The issue of getting the conversation started is something that wasn't picked up, but I'd just like to mention that before we move on. You might have read in your readings that before the Khmer Rouge Tribunal came around, the Khmer Rouge history was not taught in schools, which is unbelievable considering the dramatic impact that period in Cambodia's history had on the population and on the development of the country. But there was no teaching of that era in schools. Since the Khmer Rouge Tribunal has been in operation, and there has been a new textbook that has been developed by DC Camp. Did any of you come across the source DC Camp? The Documentation Centre of Cambodia. That came about through a Yale University Cambodian Genocide Project, it was called, to basically document the Khmer Rouge atrocities, way before the Khmer Rouge Tribunal was ever even considered. So the DC Camp sponsored textbook for high school kids is now being used. You hear written a fair amount by researchers and scholars, certainly anthropologists, who talk about how the trials have got people talking about what happened to them, because for decades, for 30 years, it was taboo. You wouldn't mention it. We'll come on to the concept of truth-telling in a few seminars' time. But I'd just like you to sort of reflect on this concept of how perhaps there are some positives to come out of the Khmer Rouge Tribunal. I have to say that from my own personal perspective, I continually question the relevance and the use of the Khmer Rouge Tribunal, and I did so even when I was there. Personally, it was quite a challenging environment to work in. But I always keep coming back to the "it's better than nothing" argument, which isn't a particularly strong argument, but it's one that I was comfortable with when I was prosecuting there. As long as I could do my job as a British trained lawyer in the courtroom and do it to the best of my ability, do it fairly, so where there was no evidence, not charge, where there was some evidence helpful to the defence to disclose that. As long as I could do that, I could square it to my conscience. But yes, is it flawed? Certainly. Any other last comments or thoughts?
From this last point that you said about the history that it wasn't taught in the schools of Cambodia, I was thinking that probably the role of the court was instead like kind of rehabilitation, like we saw also from the theories. So it can have different perspectives, the retributive, the deterrent, and also the rehabilitation, but for the society, not for the victims or for the perpetrators in this case. So probably that was the role that the court was playing in this case, just to bring the truth or a kind of truth together for the society so they can move forward and actually look for another kind of future and have in mind what happened, but also kind of heal the wounds and keep on going with the life. Something like that.
That's a very good point, Maria. I think the rehabilitation impact of the Khmer Rouge Tribunal is something that we can really consider. So, you can say?
Yeah. If you look at the VCCC structure, there's a victim support section.
Yes.
And the fact that there exists a victim support section and it's not just about criminal trial and prosecution, but also going slightly beyond, if not way too much, but slightly beyond to understand, like, and being, offering some sort of support to the victim, takes this model of the ECCC, though flawed, that could be implemented where there is more aspects of transition than in some ways it's just not prosecution, but also, victim support alongside it.
Excellent. I mean, that comes back to what you were saying, Brian, about giving the victims more than just the convictions. And it really was a dramatic experiment of international criminal justice at the Khmer Rouge Tribunal to have such a central role for the victims. As was said by both groups, this was and is a civil law-based set of prosecutions, in contrast to the common law that we had with the ICTY and the ICTR and the Special Court for CREO. So what this means, in civil law, there is a very different role for the prosecutor than there is under common law. There's a very different role for the judge, and there's a very different role for the victims, and as they call the parties civiles, the civil parties in French. So in the French-inspired civil law that relates to, that pertains to the ECCC, victims who can demonstrate that they suffered a loss as a result of the crimes are entitled to be present in the courtroom during the criminal trial to claim satisfaction from the court as a civil party. So that means they have their own representation, they're entitled to look at the case file, to cross-examine witnesses, to put up their own witnesses, and to make submissions on law and on fact to the judges. And that was done very much in an experimental basis, but it was consistent with Cambodian and the French-inspired Cambodian law. It was a very big part of the first trial, the Duik trial. So whilst you only had one accused, represented by two lawyers, and like all of the other officers in the Khmer Rouge Tribunal, there is one internationally appointed and one Cambodian government appointed. So the defence had two co-counsel, one French and one Cambodian. The prosecutors, so there was me and there was my Cambodian colleague, so again, co-prosecution. The judges, there were, at the five in the trial chamber, there were three Cambodian and two international. And then there were the civil parties, and there were, I forget the total number of civil parties in the first trial. I want to say something like 90, it might have been less than that. Of course, they couldn't all be there in the trial at the start. That's actually a picture of the courtroom. So it's a massive quadrant, wedge-shaped quadrant. And in the point of the quadrant is the courtroom, and there's floor-to-ceiling bulletproof glass with the auditorium seating 500 people. In the courtroom, there's only space for about 30 lawyers, and at least half of those were civil party lawyers. So the civil parties, the 90 or so that there were grouped in distinct groups, represented by Common Council, Common Civil Party Council. Now that is something that was considered at the time to be a real advancement. It was putting victims and civil parties at the heart of the criminal trial in an international criminal tribunal. It was the first time that it ever happened. And yes, there were problems. There was a lack of focus amongst the civil party lawyers, asking all sorts of questions that were tangentially or not at all relevant to the subject matter, to what they were hoping to get out of the process, and it lengthened the process dramatically. And so when it came to the bigger second trial, case number 2, with the senior leaders, the process was rejigged so that there would only be 2 civil party lawyers in the courtroom, the lead co-lawyers for the civil parties. But nevertheless, there is still victim and civil party participation. So that's something that is deserving of some credit, or the ECCC is deserving some credit for, I think. Is it perfect? Certainly not. How does it fit in the development of international criminal law? Well, it's another step in the iterative process, I think. Let me just think if there's any other points. Any other comments before we... Actually, one point I was going to mention. a lot of these international tribunals have very grand, you'll see this in the statutes if you look at any of them, they have very grand concepts of what they're for. They're going to be ending impunity, they're going to be putting a stop to this, they're going to be developing that. And one of the big claims that was made about the ECCC was that it was going to have a capacity building effect on the local court system. You recall that we said that Cambodian courts were particularly poor, no rule of law, a lot of corruption, bribery. The idea being here was a model court, an exemplar court, that was going to be run according to proper international standards, give or take, but there was a proper, robust defence, there were independent judges, there was cross-examination of witnesses, there was the presence of the accused in the courtroom, none of which existed in the Cambodian domestic process. But really, how has that played out in practice? The reality is that although this is the extraordinary chambers in the courts of Cambodia being situated, at least in semantic terms, within the Cambodian court structure, it has nothing to do with how the Cambodian court system has been operating. And the comments that I've heard, I was back in Phnom Penh in September, interviewing some colleagues on the project I'm working on. They tell me that there's been very little impact of the courts, the ECCC, in the domestic courts. Some very brave Cambodian domestic defence lawyers will occasionally use human rights arguments, due process rights, the International Covenant on Civil and Political Rights arguments, but very few. And those that dare use them are shot down by the judges to say this is not what we use in the Cambodian courts. So the dramatic claims of capacity building is something that deserves very careful scrutiny. Having a good time. Any last points before we have a 5-minute break or so?
The Khmer Rouge people prescribed
Prescribed?
as in banned.
Yes, it did. I think there was a law passed in Cambodia prohibiting Khmer Rouge. But there are still, decades after the Khmer Rouge were driven from power, those people, there are still people that are sympathetic to their objectives. They're in the borders, close to Thailand, and if you go to, I'm sorry, I forgot the name of the country. No, I was thinking on the border towards Thailand, not Kampong, I forgot the name, it'll come back to me. There are people that still have pictures of some of the top Khmer Rouge commanders in their houses. But they're, as a fighting force, as an organisational political force, they're totally expended.
The government's still left wing now.
How long have we got about this? So, Hun Sen is nominally an elected Prime Minister, but in fact he, in all the metrics, is known as one of the longest serving dictators in the world. He's been in power since the late 80s. He silences his opponents. He's just passed a law, I was reading on Twitter this morning, just passed a law enabling the government to ban opposition parties. So he's, yeah, it's a dictatorship in all but name. Sorry, what was your name?
Oh, sorry, Cal.
Right. Okay, we'll have a 5-minute break or so just to stretch your legs. We'll be back here at 2:10. Thank you. We've touched on already in the first half, but we'd do well to just restate them. So the big article that deals with this is the Alcman article, and in this she talks about distinguishing between ordinary and extraordinary evil. Who wants to kick us off with a few thoughts on the Alcman article and on the concept of evil, or ordinary or extraordinary or otherwise?
You know, argue that ordinary evil can be understood on a small scale, but extraordinary evil is an abstract.
What do you think about the concept of evil as it applies to something that we can punish or something that exists?
That's compared to something you can punish. You can understand dealing in terms of punishment. I think it's not the psychology of the individual.
Okay. So you would say evil, yes, it exists, yes, you can punish it. Okay.
Well, if it's evil as in harm to another.
So any harm to another could be considered evil.
It's a negative.
Okay. Okay.
For me, well, personally, it's just a word ordinary. It doesn't sit well with me because it kind of normalises some usual crimes, such as murder.
Yeah.
So, well, how do you quantify? At what point does normal murder, I mean, extraordinary murder, that thing just doesn't sit right, just don't like murder. Ordinary just normalises violence and human action.
Would you use the term evil? Would you support that as a term? I'm not saying you're wrong in some saying that, I'm just interested in your thoughts.
I don't know, I think that evil for me has quite a sort of Christian moral sort of roots for it as in terms of evil. Crime for me is a more fitting term.
It's interesting you use the term moral or morality here. So this concept of evil, the concept of the extraordinary evil, other people don't, anyone else think it's bound up in sense of morality? What would you say to that, Cal? Just go back to your name.
As I say, evil would be factual. Morality changes with the brain.
Okay. Aidan, you were saying something?
Yeah, that's what evil is, isn't it? Well, moral philosophers argue about all the time. Yeah, what is evil? And everyone has different sort of understanding.
And there's a sense, isn't there, in international prosecutions that you're dealing with senior leaders and others most responsible, to quote the personal jurisdiction of the ECCC. So the people that you're dealing with are those who organised, who planned, who ordered, who got together in their war rooms and planned the massacres on civilians or the unnecessary attacks on people that weren't fighting. Yeah, so the concept of ordinary evil versus extraordinary evil, maybe we could look at it from a perspective of domestic criminal law as well. So what's an ordinary crime in domestic criminal law? What are the general characteristics? It's very seldom political. I mean, you could, obviously terrorism is quintessentially the political crime, but your average murder, if I can use that very banal expression, is not done for a political reason. All sorts of other reasons, jealousy, greed, whatever, but not political. And it's generally on in a singular sense as well. There's no sort of systematic or widespread, to borrow from crimes against humanity parlance. There's no sense of it being part of a bigger picture. Contrast that with how crimes are conceived of and perpetrated and then punished at the international level. You're talking about system crime, systemic nature of not just perpetrating one murder, you're sending out your troops or your militia to ransack, rape and pillage entire villages. There is a hierarchy, there's a command structure to what is being ordered. And that's when you look at the political underpinnings of it. But let's bring it all back to this question of the limitations of justice. I mean, you mentioned it at the beginning, the first half of Aidan, about the ability to adequately reflect the criminality through the transitional justice mechanisms of prosecutions. Given what we know about how Akerman looks at it, does anyone have any thoughts on justice? Where might it be actually possible and feasible? Where might we spent quite a lot of time saying you can't define it, let alone prosecute it. Where might it be possible to prosecute? Or is it never really possible to encapsulate the horrors of crimes against humanity or genocide? And should we just say, because it's not possible to do it in anything more than a symbolic sense, we shouldn't prosecute at all?
Well, Ockerman says that retributive justice is just impossible in the face of radical evil. And it is also justified by the sort of fact that a lot of what sort of the instigators or perpetrators of extraordinary evil, because a lot of it is premised upon political grounds, political faces, and the sheer scale of it as well. There isn't really a feasible way that what has happened can be quantitatively and qualitatively sort of attributed to any punishment or prosecution. And I think that is why certain times people look at going beyond just that prosecution and looking at sort of not just a strict backward-looking sense of somebody should be punished because they deserve it, but what is going to happen to the victims after that punishment.
Okay. Does anybody remember, or can anyone bring to mind the 3 assumptions that Ackerman was making in her article?
Forgetting is unacceptable.
Yes.
The prosecutions are undertaken, they must comport with accepted standards of due process.
Yep. And thirdly,
So what's got the third assumption implicit in this article is that prosecutions are necessarily selective.
yes, so let's just unpick a little bit of those. So the 3 assumptions that Miriam Ackerman was making is, when you're looking at prosecutions, when you're looking at retributive justice, we have to assume that forgetting the crimes, forgetting the human rights abuses is completely unacceptable. And why is that? I know this might sound an obvious question, but let's just discuss that. Why is it obvious? So why is it that we shouldn't forget?
Because the atrocities are absolutely terrible, and it's not easy for a society that's been through that many atrocities to be able to forget it, and there needs to be some form of accountability, even if it's just symbolic at the end of the day, which is why.
Why does that? Let me just drill down that a bit more. Why does there need to be accountability?
So they're not repeated.
So they're not repeated. I mean, this is something that we've heard over the decades, if not centuries. And never again, nunca más, to say in Spanish about the disappearances of the revolutions there. But really, does it really prohibit? We'll come on to deterrence in a short while. But
Quoting from the reading, a nation's unity depends on a shared identity, which in turn depends largely on a shared memory. The truth also brings a measure of healthy social catharsis and helps to prevent the past from recurring.
some big words there: identity and memory, as well as truth as well. So what is a society if not the group of people within it? Do they have an identity, a shared common identity that they are able to move forwards with? Or is it continually contested? And the contestation of the identity, is that something that drives the conflict? And unless that identity or the contest around the identity is dealt with, you'll just have a perpetual cycle of violence, say the theorists. Yeah?
Talking about the identity, it has been said from the reading that prosecutions does not always help to create like a same kind of thought in the society. It could also divide the society a little bit more. So therefore, it could be like other kind of options to look for justice, but also to try to heal the society, like truth commissions or other kind.
Can you give me an example of societies that might have been polarised by prosecutions at international level?
Not really, I cannot think of
Anybody think about any?
Balkans?
Absolutely. Number one, poster child for polarisation as a result of prosecution in the Balkans. So the ICTY in The Hague was set up specifically to deal with the violence in the former Yugoslavia. It's not the only transitional justice mechanism set up to deal with the past. In each of the constituent countries, as they've now become independent, in Croatia and Serbia and Bosnia and Herzegovina, there are domestic prosecutions of the war crimes going on. But really, at international level, in The Hague, where this tribunal has the trials, there has been huge criticism of the way, the impact these prosecutions has had on the local communities. You speak to a Serb about the Hague Tribunal, they have nothing but bad things to say about it. You speak to a Bosnian about, I'm talking big generalisations here, but I've worked a lot in the Balkans and I've spoken to all the people there in a non-scientific survey, I should add, but there doesn't appear to be much good said about the International Criminal Tribunal for the former Yugoslavia. So then you ask, well, why is it there? Is the international community putting this on to salve its own conscience? Is it there to establish the norms, to ensure that the constituent societies of the Balkans, which of course are a smaller part of the wider international community, are we, in the broader sense, establishing or attempting to establish moral norms by prosecution? And that's where we come back to the question of accountability. If we just let this pass, what are we saying about the rules in which our society, or by which our society lives? Okay, so that's forgetting is unacceptable. The second assumption that Ahmed talks about is prosecutions, if undertaken, must conform with due process. Who wants to say something about that, about due process? We've mentioned it already in relation to the Duiker trial.
I don't think due process always works within the criminal justice system. While there is an insistence on due process of law to be followed during all criminal proceedings, they seem to make very convenient exceptions when it comes to terrorism and, and war on terrorism, basically. The entire premise of the framework on the war of terrorism does not believe there needs to be any justification or any due process of law that needs to be followed.
And what's the basis of that exceptionalism, do you think? Why should those that prosecute the war on terror and those that arrested the masterminds of 9/11, etc., why do they say that there should be no due process for these people, the accused?
Right, with presumption of guilt, just prior to trial, already presuming that the person is guilty of what they're being charged of, or it could also just be the biased nature of the jurors or of the judges as going to constitute sort of lack of fair trials.
I was thinking of complicity as well, to silence witnesses, like in Europe. The Germans were not allowed to accuse versions of the disruption technique. The Germans were not allowed to say, well, the Americans did this, and the British did this, and the Russians did this. So by not having the trial.
So you've mentioned there what's commonly known as a tu quoque defence, so I shouldn't be punished because you've done it also as well. But I want to come back to what Brian said. And Brian, you raised a very, very good point about the presumption of guilt at international criminal justice level. Obviously, the presumption of innocence is a cornerstone of the rule of law. that somebody should not be guilty, presumed guilty, until and unless the evidence has been put before the court properly challenged. But is there not something approaching a presumption of guilt at international criminal level? What are the responses to acquittals at international tribunals? Absolute horror. How on earth could it possibly be that somebody who is accused of these crimes, how could they possibly be acquitted? Well, the answer is, well, A, there wasn't enough evidence, or insufficient evidence to prove beyond a reasonable doubt. B, procedurally, there were problems with the trial, with the way the prosecution was put on. Or C, well, I can see the first one similar to A. The witnesses just didn't come up to proof. And the legal theories such as joint criminal enterprise and other formal forms of liability hasn't established that the leader that you're prosecuting is sufficiently connected to the individual crimes perpetrated by the foot soldiers. So that's one thing that I think we should keep in mind, this concept of presumption of guilt. A few people had their hands up before I came back to Brian's point. Yeah, very
I was going to say that related to the due process, we have to bear in mind the idea of from the reading they say that only primitives hate criminals. So, it's quite strong, right? But, the idea of due process is also to protect human rights of the perpetrators in order to guarantee that the process is going to be according to the law. And also, I think it gives legitimacy to the process and to the courts, which is pretty good from the point of view of the society. So I know sometimes it can be very accurate for the kind of crime that they are treating, but also I think it's necessary in order to guarantee the legitimacy of the process.
Legitimacy, that's a very good word. It's exactly what we're thinking of when we say, well, why should accused at international tribunals have the same due process rights? If not, what do you have but a show trial? What is a show trial? An illegitimate expression of punishment, an illegitimate political trial. And Aukerman reminds us of the words of the former Czech Prime Minister Václav Havel, who says the reason why we have due process is so that we can demonstrate we are not like them. Very simple but very powerful words as to why we should stand by these principles of due process, why it's argued that we should stand by. For legitimacy, there should be procedural safeguards. But all very well to have that, and all very well to have the noble ideal that it's legitimate to hold these trials with due process. But what do the ordinary people on the streets think? How do they see it when Barryagwiza, one of the accused in the ICTR in Rwanda, was acquitted because of the violation of his procedural rights? Maybe I should spell that for you because it's not as obviously Barryagwiza. Okay, so Barryagwiza, and I'd encourage you to look at the ICTR's judgment on that. Barryagwiza was, according to one of the commentators, one of the most culpable individuals for the Rwanda genocide. Why? Because he was behind the Radio Livre Mille Collines, the radio stations that put out the orders to kill the Tutsis. And he was tried for genocide, and the appeals chamber acquitted him. In fact, they held that the process that had led to Barryagwiza being before the tribunal was an abuse of process, because he had had his due process rights violated. He'd been held without trial, without charge. And as a result of these major breaches of his procedural rights, he was acquitted. There was an absolute uproar at this, and a differently constituted appeals chamber at the ICTR reversed the first appeal chamber's judgment, saying that notwithstanding these breaches of his fair trial rights, his due process rights, his right to trial within a reasonable time, his right to be released without charge. Notwithstanding that, there were circumstances which led to the necessity for confirming charges against him, the overwhelming evidence, the need in the international community and amongst the population to have this trial go forward. And Barry Aguiza was cited in the Duch trial in Cambodia by the defence team, quite rightly, quite properly, because they were arguing that Duch's unlawful pre-trial detention prior to coming to the Khmer Rouge tribunal was similarly a gross abuse of process. And in fact, that was originally why Duch got 35 years as opposed to life imprisonment, because the trial chamber recognised that this violation of his due process rights required reflecting in the sentence. So instead of being life, it was commuted to 35 years. That was actually quashed by the Supreme Court. The Supreme Court said the violation of the rights were not sufficient to justify any reduction of sentence from a life sentence. Very well, you read the judgments yourself and you'll see the standard of reasoning. I would argue, and this is my own view, you can make up your own mind about it, I would argue that there's an agenda to convict all of those against whom there is evidence beyond reasonable doubt, regardless of any violation of procedural rights. Going back to this idea of what will the international community say, what will the population say if somebody is acquitted. And finally, this point, this assumption that Alckmin makes of prosecutions being necessarily selective. What do we say about the selectivity of international trials? Is it right that we should only pick a handful of people to be prosecuted at international level?
There's the case of practicality. You will never prosecute every single person ever. So it's your command responsibility in a way. You can go for the platforms because we have level of capacity. What is it? In terms of resources, no country or no international body will ever have resources.
Sorry, remind me of your name?
Deep data.
So, thank you for that, Dee. Vivi, you want to come?
Yeah, I was just going to say the same thing. Because of the scarcity of resources, it could be time, it could be availability of judges, tribunals, money. So the focus is on the few, on few who are more reliable than the rest.
Yes, so we've got basic resource questions. We've got practicality questions. Maria, you going to say something?
Yeah, I was going to say that sometimes one of the problems with the selectivity of the prosecution is that they don't go to the heads of the crime. They can go to people who are actually doing the crime or committing the crime by orders, because they can only prove the crime for them, but not for the head of the crimes, and that's one of the big deals for the selectivity of the prosecution.
So it might actually work the other way, is what you're saying. So although the international criminal law requires the prosecution of the most responsible, the senior leaders being the most responsible, because there might be difficulties of proving the nexus, the link between the people that ordered it and the people that committed it on the ground. Sometimes you're actually left with just prosecuting the people on the ground, the people that pulled the AK-47 trigger or wielded the machete. Yeah. Right?
But also not forgetting the aspect that if a large number of people are prosecuted from a certain region, it's very possible that it could be politically destabilizing and socially divisive as well. Because especially in sort of conflicts or wars that have been ethnically fueled, could easily degenerate into socially divisive persecution.
Very good points. Right, yeah. Levon, do you want to say something? Yeah. Hey?
I wanted to say that I think there's a case that definitely a strong argument to say that it's more immoral to selectively punish people than in sort of the argument that at least some people are being punished for their crimes. I think it's more immoral to selectively punish people primarily because it presupposes the idea that some people have human rights while others don't necessarily have human rights.
What about the basis upon which that selection is made? So the point Abe is making, so immoral to only select a handful of people to prosecute. What would your point be the same as if you were looking at a particular basis for the prosecution for that selectivity, would you say?
Potentially. I mean, I understand that there's political considerations and obviously there's practical considerations as well. But the idea of it being selective, it just strikes me as being sort of a lot more immoral than universalising the idea that we go to prosecute crimes against humanity and war crimes and things like that.
Cal, Level, do you want to say something, Cal?
Doesn't that go to the case itself? Isn't the case focused on the wrong thing? Like ECCC focusing on individuals and only 5 or 8 people being prosecuted, 1 person in 8 years. Should not be focused on a group of people. And by the way, include, say, if you take British, we say British did something wrong. Right, we'll obviously in Band A, we'll include the cabinet and the Prime Minister, and Band B with the military leaders. All those that are included in those bands, we'll prosecute them as well, rather than saying, well, we're going to prosecute Pol Pot on his own, and then S21. And then only have 1 prosecution of 1 individual in 8 years. So if there's a band, we'll prosecute as a band because you're in that band, and once convictions come down, all, say, 20 people in that band, bang.
Interesting thought. Levon, you've got to come.
Yeah, when you talk about the importance of due process, it wouldn't be even more difficult to process like thousands of people, hundreds of people if you were an account like. Obviously you're going to lose your way with due process, so that even it brings in more complications to whether the trial would even be fair if it even were to process them. So.
I think so. Yeah.
I would disagree with Cal's approach purely because I can only presume that in cases of massive commit a lot of crimes against humanity, a lot of the people that did commit them or were specifically involved, they would still wield some kind of power, so you can't eradicate them all, and that would in turn potentially destabilise, potentially these repeats, which is going back to the specifically research stuff, to peace versus justice. I think by trying to prosecute large numbers of people that may still have power, you would destabilise them.
Good points being made. Yeah. We'll move on given the time. We've got still a couple more slides to go on. Yeah. Okay, so we'll now come to the issue of retribution and vengeance and the distinction between the two. What is the difference? You can tell me what the difference is. Okay.
I would say state versus individual. So I would say that retribution is something that the state gets to see to they try to right the wrong that they've committed, and vengeance is identified as individual characteristics. You seek vengeance, you try to eye for an eye.
So there can never be a vengeful state, there can never be
I'm sure it can be, but on paper, so to speak, they should be seeking retribution as opposed to vengeance.
Ruth?
I think I say it more of like where it comes from. I think that vengeance comes from a place of wanting revenge. It comes from this idea that you, like an eye for an eye kind of thing, whereas retribution I see comes from a place of it's going through a process for justice, it's finding justice, it's what they deserve because of something they've committed. You're not doing it because you've got so much anger in you. You're doing it because it's what's just and it's what's right to go through retribution.
So on the one hand, you've got visceral anger, hatred, almost primitive, primeval reaction to something that somebody's done. And on the other, it's orderly, it's formal, there's a process. Yeah. Any developments on that? Any thoughts on that?
I was going to say something, but I don't think I'm right. I had the idea of proportionality of retribution. It's looking to give a proportional punishment, whereas vengeance is just doing the same to the other, to the subject. I don't know, I'm not sure if it's...
So the proportionality aspect.
Yeah, but I don't think it fits in this case.
Anybody else like to take up that?
I agree with Maria. I think it's to do with proportionality as well, because when you consider retribution, you're fitting, like Ruth said, you're fitting the crime to the punishment, and which differs so much from vengeance because you've got that singular mentality of that one person or that whoever saying that they want to be able to give a punishment that's what they think is proportional to the crime that's being committed. So I think proportionality is definitely an issue there, but I think the two can overlap, and I think you can, some people do achieve their own personal vengeance through retribution. Makes sense?
That's interesting. Yeah. So this idea of proportionality, something that needs to be calibrated, that needs to be some sort of formal system, would appear to adhere to this concept of retribution in a way that it doesn't to the notion of vengeance, revenge. What do you think about this concept that is often bandied around in transitional justice or international criminal justice terms of combating impunity? Is it useful? Is it helpful? Is it necessary? Any thoughts on what that might mean?
I think a lot of times when countries move into transition, a lot of power sharing agreements that come into place, and a lot of times people are given amnesty and things of that sort. So, despite having committed a certain amount of crimes against humanity or war crimes, they're given this sort of impunity, and I think it's being able to combat that impunity and making sure that rule of law persists, and that despite the existence of whatever agreements and everything else, that people are still held accountable. And I think accountability enforcing accountability is what combating impunity is at the first step to.
Anybody like to comment on that? They're good points. So, I always find that it's helpful to compare this either with a specific example or compare it to domestic processes. So, if there was the evidence of a burglary that took place down the street, or a collection of burglaries that took place down the street here in Liverpool, there wouldn't really be any sense of the police just picking one or two, or picking one symbolic burglary and then moving on. They would have the resources, hopefully, and the evidence to prosecute all of the burglaries. But this doesn't really translate onto the international scale. And this concept of impunity, the concept of people getting away with not just the odd burglary, but big crimes. Jessica, you going to say something?
Yeah, I think with impunity, I think it's a very difficult topic to fully wrap your head around, at least for me anyway, within the international sphere, solely because, like, for example, with me, I grew up in post-apartheid South Africa, so I saw what Amnesty's, the direct impact that Amnesty had on the transition there. And in that sort of instance, impunity or amnesty or whatever, getting away with what you've done, is actually far, at least in certain aspects, far greater than going, oh, we're going to just throw all these people in prison and see what happens there. Because at least in that instance, you know, there was that need for the truth, there was that need, like that's what normal people wanted than prosecution. So I think with impunity, it's a very difficult thing to actually, I don't think you can fully say, oh, well, it shouldn't happen, or it should, because I think it depends entirely on the situation at hand. I think amnesty, in certain aspects, can be a very great tool, and therefore, you know, without it, I think there are a lot of instances where, without amnesty, you wouldn't have the end to a conflict that you need. And so, you know, there is that sort of question of, do you give impunity, give amnesty, whatever that may be, stop the violence, and then, you know, do something like, I can't think of an example, Chile or something, where you prosecute many years later, where the democracy is, you know, a bit more stable, or do you just continue with the conflict and then try and eradicate that, and then sort of say, well, we don't need impunity now because, you know, we won. And I don't know what the best answer is.
So we're back to the questions of peace versus justice that you've already been discussing, no doubt, with Padraig in the first 3 seminars, but also other sort of wider questions that we'll be looking at later seminars as well. Okay, so before we get on, let me just see how far we want to go. We've got 2 more. I was going to split you up into groups about this, but we've had such a long discussion. We will perhaps just do this in class. So, deterrence. Yes, it works. No, it doesn't. What do people think? I can see some heads being shaken. So, is anyone prepared to argue that there may be grounds for saying deterrence does work? Yes?
Only from the perspective that we only really focus on instances where there has, so we're aware of the atrocities that have happened, you know, since World War II, but we don't really ever focus on perhaps those regimes that haven't been in the public eye as much, because you know, it's only the atrocities that make the news and get into the history books and everything. And you know, there may have been other regimes where I don't know whether there's been research done on this, and I can't really think of any specific examples, but you know, there may be situations where a regime may have been going off in that direction, but didn't, because they were perceiving what was happening, you know, with criminal tribunals or you know, the development of human rights law in international sphere.
I'm glad you mentioned that. Sorry, your name?
David.
David, thank you, David, for sticking your head above the parapet on that more difficult side of the argument. What about, who's going to make the opposite side of it?
There's the same argument.
Okay.
Yeah.
Right.
Maybe deterrence works not because of the fact that, just because of the fact that there is punishment for something, but also because there have been better mechanisms that have been put in place since an atrocity has occurred. There's a constant change in political systems and judicial systems. So the fact that all of this has evolved as well points towards the fact that, you know, all of this also acts towards deterrence, apart from just criminal liability.
Yes. Yeah, I think there's a fair point. You might also argue, well, deterrence isn't absolute even in the domestic criminal sphere. Just because we have murderers convicted and burglars sentenced to 3 years for their 3rd strike and they're out, it doesn't prevent people committing murders or committing burglaries. But that is an argument to suggest perhaps what some of the other scholars were writing about when they talked about, well, that misunderstands fundamentally the way people think in the time just before they're about to commit a crime. You know, do they really stop and think, well, I remember Charles Taylor was put away for this, or I remember Slobodan Milosevic was about to face a life sentence if he hadn't died in custody. But I mean, Padraig writes about this in the article that you were asked to read in eloquent detail about this allure that deterrence has as a concept. Are we considering, well, is it wishful thinking to deter? I mean, we see this extraordinary evil, these hugely significant crimes against humanity. Is the only way that we can conceptualize them by seeing ultimate punishment in the way of a life sentence as the saviour. Jessica?
I'd argue that it's a bit too early to tell if deterrence is actually, if it works or not. You know, since the first case of the ICC, there hasn't been that many cases, especially in terms of gross human rights violations and all that sort of thing.
Yeah.
Since the beginning of the ICCC, and I just think it might not be. I don't know if deterrence does work, but I think it's a bit too early to actually fully tell if it does or doesn't work, because we just haven't had a significant period of time or any kind of examples to sort of go, oh, well, you know, since the 70s there's been a huge decrease in the amounts of, you know, war crimes or whatever. So I'd argue that there's not enough time to fully say yes or no.
Okay, good point. I think that's probably a good point to end on. We've already dealt with due process, selectivity, good practice perhaps less so, but we're pretty much out of time. So before I come on to next week, anyone got any final comments or thoughts or questions about retributive justice and prosecutions? No? Excellent. Okay, well thank you very much. Next week we'll have a seminar all about reconciliation and restorative justice. I'll put the materials on Vital later on, and I will assign you the groups for the small presentations. You know now how it works, having had it demonstrated so beautifully for you earlier on. Thanks very much. See you.